in a rough weather, my lord.
And unpopular cases.
Yes, yes.
Yes, Mr. Ansari.
My lord, I'm pleased. My lord, my submissions, your lordship will get it in volume 2A, page 47. Volume 2A, page 47, my submission starts. But before I take your lordship to the submissions, my lord, may I just briefly summarize, my lord, what I intend, my lord, to persuade your lordship, my lord, to agree with the minority view, to say that, my lord Justice Bharucha, my lord, the test propounded is the nexus test. And Justice Agarwal propounded essential and integral part test. Lord, my lord Justice, nexus test is in paragraph 133, 134, 135, 136, and 145 of Narasimha Rao judgment. Justice
133, 134.
133, 134, 135, 136, and 145 is the nexus test propounded and, my lord, held to be the correct law by the majority. And my lord Justice Agarwal test was essential and integral part test in para 47, which my friend Mr. Sankarana also said essential and integral part test would be the correct test, my lord. And my lord, lordship would kindly make a note, my lord. It is not only a case of bribery. It will.
Justice Agarwal is para 46. No?
Para 47, my lord. I'm so sorry. Para 47 is the, my lord, essential and integral part test. And I'm so. And my lord, what your lordship says is not only in relation to an offense of Prevention of Corruption Act. It gives immunity to all sorts of crimes committed, my lord, if at all. Hopefully not, my lord. Suppose, my lord, there is a nexus with an underground organization, terrorist organization, to vote in a particular manner. There is a meeting on a previous day. And say that a terrorist organization says you don't vote or vote in a particular manner. It has a nexus. If nexus theory is accepted, my lord, that immunity is applicable to an offense under the UAPA Act also. That offense is that immunity is available to an offense under the PMLA Act also, or various other acts, my lord. So, my lord, to say that it's only, my lord, the bribery issue is involved, my lord, what your lordship would say, my lord, would involve all crimes, my lord, which unfortunately we have, my lord, the list of more than 5,000 crime cases pending against, my lord, the legislators in the country. And it is not a spray incident of 1 or 2 cases, my lord, which has come to a lordship, my lord, in Narasimha Rao or in this case, my lord. With that preface, my lord, may I just humbly meet, my lord, the 4 submissions which my learned friend Mr. Ramachandran made, my lord. And my lord, take your lordship to my written submissions thereafter. The first test, my lord, first submission which my learned friend Mr. Ramachandran said that it has stood by the test of time, Narasimha Rao judgment, my lord, which is not correct, my lord. Your lordship have repeatedly doubted it, my lord. And Mr. Sankarana has dealt with the aspect. I don't want to give it, my lord. If mistake is there, it must not be perpetuated, my lord. That is what your lordships have held. The second is, my lord, more disturbing. My learned friend says that corruption is a way of life in our political spectrum. Accept it, my lord. Which, my lord, cannot be done, my lord. Ayaram, Gayaram has been there in 1967. It is there, it was there, and it will be there. So turn a blind eye to this, my lord, which I would commend your lordship to say, my lord, to interpret the privilege in a manner which will not flourish the, my lord, the criminality among the politicians or the political class. It will, my lord, curb the criminalization of politics, and it will not surge it. An interpretation your lordship would give. So that's saying that you accept the reality, and the court should turn a blind eye, my lord, that yes, it will be there, it was there. It should not be a correct, my lord, proposition of law. Because, my lord, I will give you the facts, and it is there in the on record available to the court, my lord, that how many cases are there. We have cases, my lord, more than the parliamentarians or the legislators in the country. We have total 4,778 lawmakers in the country, my lord, all MLAs, all MPs, both houses. And we have more than 5,000 cases against the politicians, my lord, pending in the courts as on date, my lord. So would your lordship say, my lord, all that the person has to say, I have this offense has a nexus with I have done in the house. Nexus theory is sufficient to exclude him from the criminal liability. But that interpretation would go against the constitutional ethos, my lord, against the constitutional morality, which I have developed in my written submissions. My lord, my learned friend also says that the Justice Agarwal says it's not a satisfactory solution. The court is not there to satisfactory solution. It is the parliament which will read it. And my learned friend gave 5 examples, my lord, since 1947 till 2023, where parliamentaries has been expelled for some time. My lord, is it a substitute, my lord? We know, my lord, these offences have been there, and my lord, for 5 occasions, it has been expelled for, say, 5 days, 10 days, 15 days, a month. Thereafter, my lord, he comes back as a member of parliament. But if he is convicted in a criminal offence, my lord, he cannot come back. And as on date, my lord, till 6 years of the release, he does not come back. He cannot contest the election. So he cannot continue to be a parliamentarian, my lord. But if those 5 instances is the sufficient, my lord, exercise of power by the legislature or the house, my lord, which, as Mr. Sanghan said, we expected much more, my lord. It has not happened. So, my lord, it has to be taken into consideration, my lord. That is not a satisfactory solution as observed by my lord Justice Agarwal. And finally, my learned friend says there is an apprehension, my lord, of misuse. My lord, apprehension of misuse is being said by a person who has taken 1.5 crore to vote in a house, in an election, my lord. And my lord, there is a sufficient safeguard. There is a sanction is required for prosecution by the chairman and the speaker, my lord. Where is the question of, my lord, a frivolous prosecution? You require the sanction of the chairman of the Rajya Sabha. You require the sanction of the speaker of the Rajya Sabha. So there is a sufficient safeguard, my lord, against any apprehended misuse of any provisions, my lord. With this preface, my lord, may I request your lordship, my lord, to kindly come to volume 2A, page 47. The first 2 pages are regarding, my lord, issues involved. Your lordship has already considered it at great length, my lord. At page 49. It is submitted that, my lordship, what?
Yes.
Yes. That the constitution must be interpreted having regard to the challenges and evolution over a period of time and must reflect the hopes and aspirations of the people. It is not a frozen document, my lord, which I borrowed it from your lordship's judgment, my lord. I'll just quoted it subsequently. And must be interpreted to meet exigencies of time. My lord Justice Chandrachud's lordship then was in Puttaswamy held. The interpretation of the constitution cannot be frozen by original understanding, which is sought to be canvassed, my lord. And constitution has evolved and must continuously evolve to meet the aspirations and challenges of the present and future, nor can the judges foresee every challenge and contingency which may arise in future. Lord, we never foresee, my lord, that so many persons with criminal background would come to the August House of Parliament, my lord. But this is what has happened. So it has to be in that context. Then in Kalpana Mehta, the Chief Justice Deepak Mishra said, Constitution being an organic document, an ongoing interpretation is permissible. The supremacy of the Constitution is essential to bring changes. Then while doing so, the constitutional courts are not only required to take into account their own experience over time, international treaties and covenant, but also keep the doctrine of flexibility in mind. And my Lord Justice Chandrachud has said, my Lord, in the same judgment, in finding an answer to the question in reference, this question must of necessity travel from a literal and perhaps superficial approach to an understanding of the essence of what the Constitution seeks to achieve. At one level, our Constitution is overseeing the power of political power from a colonial regime. Lordship may skip over that and last 3 lines of my Lord, page 50 of our interpretation of the Constitution must reflect a keen sense of awareness of the basic changes of the Constitution has been made to the polity and to its governance. A 5-judge bench in Dawoodi Bohra community has laid emphasis that the Constitution must be interpreted as a living instrument considering the changes in the society. My Lord Justice Oka has held in that judgment, my Lord. Para 25, while interpreting the constitutional provision, we must remember that the Constitution is a living instrument. The organist interpretation rendered by the provisions of the Constitution decades back cannot continue to be valid for all times to come if the Constitution is to continue as a living instrument with continued relevance. In view of what we have stated above, the role of the Constitutional Court to interpret the Constitution, considering the changing need of the society, assume importance. in the light of the aforesaid pronunciation by this court, my lord, yes, my lord, all these 11 pages are, my lord, given, my lord. I have filed this before the compilation was available, so I have not linked that, my lord. Maybe I'll give it to the court master, which, because these are, my lord, in compilation 5, page 2794. I could not give it because I filed it, my lord, before that convenience compilation was there. So I'll just give those, my lord, to the court master so that it can be linked, my lord. Or in the light of the aforesaid pronunciation of law, by this honorable court, it is respectfully submitted that the issue of immunity from criminal prosecution by the legislators under Article 1052 of the Constitution need to be interpreted in the present context. I'm so sorry. In the present context, where there is extensive criminalization of politics and large number of persons with criminal antecedents have entered the parliament and the legislative assemblies. Now, these figures are very startling, my lord. These are, my lord, from the proceedings, my lord, in another case. This honorable court in the PIL filed by Ashwini Kumar Upadhyay directed setting up special courts and MPs, MLAs and passed a series of directions. However, the number of pending cases have increased from time to time, and the number of cases, my Lord Justice, Chief Justice, my Lord Justice Nashima, my Lord Justice Mishra has heard this, my Lord. But for your Lordship's benefit, my Lord, on other honorable judges on the bench, in December 2018, there were 4122 pending cases, of which, my Lord, 1675 were against MPs and 2324 against the MLAs. Out of these cases, cases involving life imprisonment or death penalty were 430. So 430 cases of life imprisonment were pending against legislatures, 180 against sitting MPs and 250 against the former MPs or MLAs. In December 2021, after Lordships have passed series of directions in that case for expedited trial, the number of pending cases were increased from 4984, out of which 1899 were pending for more than 5 years. November 2022, the number of cases further increased to 5175, out of which 2166, 40% cases are more than 5 years old. Now, in a report of the Association for Democratic Rights, 234 out of 542 members of Lok Sabha, 71 out of members of Rajya
Nobody is
Sabha.
claiming a 105 privilege in any of those criminal.
No, this shows
Not
Lordship would
necessary.
take into account these figures, my Lord, while interpreting the provisions of the Constitution. That's what I'm trying to emphasize to your Lordship, my Lord. Then, my Lord, there are various reports and
can go
committees.
straight now to page 61, parliamentary privilege, not a shield to commission of crime. That is
Your Lordship, my Lord. My Lord. Para 61, my Lord, page 61. But before that, can I just 2, 3 or pages, my Lord, just show to your Lordship before 2 or 3 pages, my Lord. There are various reports, my Lord, which I have quoted, Lordship, including Justice
Including the
Reddy's.
National Commission for Review of the Constitution, Justice
Yes, my
Venkatacharya.
Lord, yes, my Lord, Justice Venkatacharya
They
report.
cast doubt on P.V. Narasimha Rao in
Directly honorable, that commission says, my Lord, it's a wrong view, my Lord, and it may be corrected. And, my Lord, in Law Commission's 239 report headed by Justice Reddy, 244th report headed by Justice Shah, my Lord, has read this. And at page 54, my Lord, that Justice Venkatacharya Commission has specifically says, it is obvious, my Lord, page 54, middle of that page, my Lord, that quotation from that report. It is obvious that this interpretation of immunity of members of parliament run counter to all notions of justice, fair play, and good conduct expected from the members of parliament. I can say no more, my Lord. Freedom of speech inside the out cannot be used.
62, actually now page 62,
My Lord,
you formulate the test.
I have,
The
please,
expression
Your
with
Lordship.
respect of must be interpreted to mean only those acts that are essential for undertaking the
Lord,
legislature.
yes, my Lord.
So you are adopting the test of the.
Yes, that is the crux of my submission. Before that, can I just show to your Lordship, my Lord, volume 4, page 1513, what May has to say, my Lord, and I'll commend your Lordship to accept that interpretation. Volume 4, page 1513. It starts. And yes, paragraph 16.4. I'm so sorry.
What is this document? This is a.
No, this is the document starts, my Lord, from, it is the May's parliamentary practice, my Lord.
2 it starts.
Yes.
What, okay.
The document starts at page
It's a
1502.
textbook.
1502. 1501 rather, heading cover page is there, my Lord, 1501. And at 1513, my lords have got it. Yes. Early and mid 20th century, many subsequent cases have their origin in the desire to determine the proper limits of the statutory phrase proceedings in the parliament, some of them with a particular concern of what is integral part of parliament or to parliament in the context its claim to exclusive in general, the judges have taken the view. Now, this is what I want your lordships to kindly consider and accept this proposition, Lord, that when a matter in a proceeding of the House, beginning and terminating within its walls. Lord, as Mr. Sankarana said, Lord, there was a statement recently, we may not like it, my Lord, but it has been said within, beginning from and terminating within the walls of the House, my Lord, that is privilege, that nothing can be done. Obviously, outside the jurisdiction of the court. Lord, so my Lord, the expression is beginning and terminating within the walls, within its own walls, would be privileged, my Lord, but nothing outside it, my Lord. And same thing is been said, my Lord, at page 1514. At the last two lines of the first paragraph, my Lord, page 1514, he contrasted those with rights to be exercised out of and independently of the House. I will say, my Lord, rights and liabilities. I'll add that word, my Lord. Rights and liabilities arising out of and independently of the House, in which the court must be the arbiter. Yes, my Lord, yes. Even within that, my Lord, I'm grateful to Mr. Patwali, I'm not learned amicus. I can read that, my Lord, 1513 again, the last lines. In general, the judges have taken the view that when a matter in a proceeding of the House, beginning or terminating within its walls, it is obviously outside judicial court unless criminal acts are involved. So there also, my Lord, if the criminal act is involved, it is not. So, my Lord, an interpretation which protects the criminal act is definitely outside the, my Lord, the privilege, my Lord. And what right or liabilities arise, my Lord, independently of the House, the court is the arbiter. That is the test, my Lord, which the May has said, and I will appeal to your Lordship to accept that test, my Lord, and lay down that as the correct law. Now, Lord, may I just summarize, my Lord, as my Lord, the Chief Justice has said, my Lord, page 62, para 27 to 29. That is my final submissions, my Lord, which I am beseeching your Lordship to accept. It is submitted that the majority judgment granting immunity to all the acts of Parliament that relates to, that is, my Lord, para 133, the nexus, my Lord, relate to or concern or have a connection or nexus. Now, these four expressions, my Lord, does not correlate, my Lord, which is sought to be, my Lord, immune, which is too wide, my Lord, with anything said or vote given in Parliament is too wide and does not encompass within the expression in respect of used in clause 2 of Article 105. The expression in respect of must be interpreted to mean not only those acts, or must be interpreted to mean only those acts which are essential for undertaking the legislative function. No privilege can be claimed from criminal prosecution. The penal laws of the country are applicable to the legislators in the same way as are applicable to ordinary citizens. The privileges are only those which begin and terminate within the walls of the House, as May has said, my Lord. All actions outside the House are subject to adjudication by the courts. The immunity conferred by Article 105(2) and 194(2) is confined, is only a qualified immunity and not an absolute immunity. The qualified immunity balances two competing rights, namely grant of freedom of speech and expression to the vote in the Parliament inside the House and hold them accountable for any crime committed outside the House. My learned friend will delve with it. It is submitted that commission of any crime can never relate to, in respect of anything said or vote given by him Parliament, and no legislator can claim immunity from criminal prosecution by seeking the protection of parliamentary privilege conferred under Article 105(2) or 194(2). Every person is liable for prosecution for offences committed by him or her under the penal law of the country. If immunity from prosecution is granted, the criminalization of politics will get a boost instead of being curbed. The immunity would be an easy escape for the lawmakers to avoid penal consequences of all penal offences, including heinous offences, by claiming that such an act was in respect of anything said or done or vote given by him in parliament, the immunity if allowed would be limited not only to corruption cases, which I started saying that, but it can be claimed in respect of serious offences such as POCSO, Unlawful Activities Act, Money Laundering Acts, hate speech, etc. It would be licensed for the legislator to commit a crime without fear of prosecution and thereafter claim immunity by creating a so-called nexus with the speech or vote given in the House. It is submitted that the criminalization of politics has been deep-rooted in the parliamentary democracy of our country. The parliament and legislature cannot seek immunity from prosecution, the garb of parliamentary privilege. The majority in the Narasimha Rao only encouraged the people with criminal antecedents to enter politics, enter the precincts of parliament strictly, and the number of such people will surge, increase or expand instead of being truncated or brought down. So, my lord, I appeal to your lordship, lord, that the minority judgment, my lord, maybe.
Thank you, Mr.
My
Sankara.
lord,
Thank
there
you.
are, my lord, may I just say this, my lord? Lord, the additional submissions which have been made, my lord, there are 4 councils who wish to address your lordship, lord, which is in volume 8, my lord, there are four councils which have said. Lordship may give 5 minutes to each of them, my lord, the 4 councils who have said, my lord, in that order only, my lord. Ms. Kalita, Dr. Sharma, Mr. Banduri, and Ms. Karyawaj Hawar, my lord. Lordship, huh? I'm saying that let it be in the same order. That's what it will be.